So chapter 11 deals with landlord and tenant. And we're going to go through this in just a little bit different order than is in your textbook. Same thing in the chapter. We're just going to kind of flip-flop talking about residential leases before we talk about the broader types of leases. And I think that's because people have a tendency to make everything about residential leases anyway, so in their minds. So let's get that out of the way, and then we'll talk about how that doesn't always have to be the case. Let's talk about the specifics of residential leases first in North Carolina, and then we'll talk about other types of leases. All right? So a leasehold or non-freehold interest is just a contract where the landlord is giving the right of possession for a certain amount of time to the tenant or the lessee. The landlord is the lessor, the tenant is the lessee. All right? And obviously, when we talk about landlord-tenant law, we most of the time in our mind focus on residential tenants. So let's start there. Let's talk about the laws that protect residential tenants in North Carolina. These are North Carolina specific laws. Every state has different laws when it comes to residential tenants and protecting them, and North Carolina is no different. So we say in North Carolina, first of all, we have this North Carolina Residential Rental Agreements Act. In North Carolina, one of the first things that we make sure that you understand is that the obligations of the landlord and the tenant are dependent on one another. In other words, one is only bound to do their job because the other does theirs. If either's not doing their job, then the other has the right to end the relationship. Ending the relationship from a landlord's perspective is an eviction. It's called a summary ejectment. Ending the relationship from the tenant's perspective is called a constructive eviction. We're going to talk about why the tenant might be able to do that. So generally speaking, what responsibilities do you think that the landlord has to the tenant in a residential setting in North Carolina? What do you think? Maintenance, maintaining the property. What your book says is the property has to be maintained in a fit and habitable condition. You have to have a fit and habitable condition for that property. So that's the main requirement of the landlord. Something you need to remember for the test. So this needs to be in your notes. Sorry, I can't help but giggle. I just saw Chris's book over there, and she's got every line on the page highlighted. I'm not sure how that really helps if you highlight them all, but just I couldn't help but notice. And I was like, why does she have a yellow book? I don't. From a test-taking standpoint, the landlord can't negotiate away this responsibility. They love to put that on the test. Can the tenant and the landlord agree that the landlord will not do certain things? And the answer to that is no. The tenant and the landlord cannot agree that the landlord's not going to maintain the property. Like, for example, the heat doesn't work, and the tenant says, well, that's okay, I'll just rent it for $200 a month less. That conversation cannot happen in the state of North Carolina. This is not a free country. In spite of what you may have heard, when you come into a real estate class, you realize how regulated it is. You cannot have that discussion legally in the state of North Carolina in a residential rental because the landlord has a responsibility to maintain that property. So whatever amount they choose to rent it for, whether that's $1 or $1,000, they have to maintain the property. Does that make sense for everybody? Good. And obviously the tenant always has a duty to pay rent. Now landlords also have to worry about this thing called the law of negligence. So the law of negligence governs this situation where the landlord could be held responsible for things that happen in their property. Could be held responsible for things that happen in their property. But basically, the landlord's not generally going to be held responsible unless they don't do something about a potentially hazardous situation. If they just don't do it. Now, just as an example, let's say we have a sudden thunderstorm and a tree falls on the house and injures somebody. Is the landlord likely going to be held responsible for that? Probably not. What if the tree had been dead for 6 years and the tenant had repeatedly said, you need to come do something about this tree? Could the landlord be held responsible then? That's what the law of negligence applies to. Okay? Unfortunately, tenancies don't always go well. Sometimes we have to evict the tenant. What do you think the most common reason for an eviction is in any state, North Carolina included? Non-payment of rent. By far the most common. What you need to know is you can't do something called self-help eviction. Self-help eviction would be things like changing the locks, locking them out of the property. They've got to bring a suit. It's a lawsuit. It's called summary ejectment. That is the only legal path to eviction in North Carolina. The summary ejectment is the only legal path to an eviction in North Carolina. And it's a suit that's heard by a magistrate generally. Generally magistrates, not judges, would hear these. You could be expelled for lots of reasons, including criminal activity in the property. But the key there is no self-help eviction. So you've got to go through that summary ejectment process. Just out of curiosity, does anybody know how long the summary ejectment process takes in North Carolina? It actually takes about 45. 30 is fast tracking it. About 45 days to accomplish a residential eviction in North Carolina. How much does it cost? Grace's question was, how much does it cost? The cost varies depending on how many tenants you have in the property, because there's a filing fee, but then there's also a service fee. Each defendant has to be served. So if you have more tenants, there are more people to be served summons, and so you have to pay a service fee for each one of them. So it can vary significantly. I think the basic filing fee in Wake County now is $190, if I remember correctly, to file the action, and then you pay the service fee for each tenant, which works out to about $35, $40 per tenant. So it's a couple $100 to file for summary ejectment, and then you have to give a long enough time period for them to be served the notice, and then to schedule the hearing, and then to go to court. So about 45 days. And that's 45 days from the time you file. They don't give you any special treatment because you waited 3 months to file. The person who goes in there and files on day 10 that the tenant is late is going to get the same treatment as the person who files on day 90 that the tenant is late. How long do you have to wait? There's a reason I said day 10. Okay. 10 days. 10 days in the state of North Carolina. If they are not paid by day 10 of the month, you may file. You may file anytime. And if you are going to become a residential property manager, I highly suggest that the best way to operate that business is file on day 10. People will take advantage. That is just the ultimate reality of working in residential property management. That you were not hired to be nice. You
They won't legally be pushed out until 45 days after that.
Correct. Exactly. Correct. That's right. You may file on day 10, but it's going to take 30 to 45 days after that for the process to unwind. And that's exactly why, if I were you, I would make it clear to them that you plan to file on day 10, because the longer you wait, you almost always just putting off the inevitable. I mean, I think most residential property managers would tell you that any tenant that gets a month behind on rent very, 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 very rarely ever catches up. Very rarely ever. Just playing the odds. I know it sounds heartless and cruel, and guess why you were hired? To be heartless and cruel. If it was easy to collect rent, nobody would hire a residential property manager. That is why you were hired. I'm sorry?
When does the notice actually go on the door? After the summary ejectment is completed?
The eviction notice? Mm-hmm. The eviction notice would be when the sheriff comes to evict them, which would be after the hearing. So generally speaking, that 45-day time period.
Does the landlord have to be present at the hearing?
The landlord does, because they're the one filing the action. Or their property manager. So it would be the responsibility of the property manager to show up in the landlord's place If the landlord was not going to be there, then the property manager should be there. So that's one of the responsibilities of a broker property manager, is to file actions that ordinarily would be done by the landlord. Okay? So what are the tenants supposed to do? Keep the premises clean and safe. Throw away their garbage. Don't destroy the property. Don't break the law. Be responsible for damages. Tell the landlord when stuff needs to be fixed. And above all, do what? Pay rent. Now let's talk about that for a second. Payment of rent under the Residential Rental Agreements Act is required at all times that the tenant is in possession of the property. And what do we say possession was? They're occupying the property. So what if the landlord doesn't do what they're supposed to do? What if they don't fix something? Can the tenant stop paying rent?
Yes.
Never. Under any circumstance. And that's going to be a test question. Can a tenant cease paying rent if the landlord does not provide a fit and habitable condition? What is the answer to that? No. The tenant does have one recourse. Move out. That is called constructive eviction. Constructive eviction is when the tenant evicts themselves. And they're doing so specifically because the landlord has not done their job. That's the reason the tenant's moving out. So, for example, heat's been broken for 2 weeks. The landlord hasn't done anything about it. You've sent him 3 emails. He won't take care of it. You can move out. It doesn't matter how much longer you have remaining on your lease. You have constructively evicted yourself. But you must pay rent up until the time you vacate the property, according to the law.
And you have to go to court for constructive eviction?
You do not go to court for a constructive eviction. You move out. You move out. I'm sorry? So that's going to be a challenge. Gray asked, well, what about my deposit, my tenant security deposit? Generally speaking, is a landlord going to be excited about returning your tenant security deposit if you have constructively evicted yourself? Probably not. Now, that doesn't mean they don't have to, because we're going to talk about what a tenant security deposit can be used for and what it can't be used for. And you can't keep it just because somebody constructively evicted themselves. Because in theory, they constructively evicted themselves because you, as the landlord, were not doing what you were supposed to do. That being said, most likely, if you constructively evict yourself, you're probably going to have to go to court to get that security deposit back, would be my guess, because they're probably not going to return it to you. Now, that being said, and this kind of follows up on Sarah's question, because Sarah said, do you have to go to court for a constructive eviction? And my answer was no. That doesn't mean you may not end up in court over a constructive eviction. Most likely, how's a constructive eviction going to end up in court? If it does. I'm sorry? The landlord's going to be mad because you did what? You broke your lease, right? And so they may file suit against the tenant in that case. But think about that from the court's perspective. The landlord is coming in and making a claim. The tenant has violated the lease by moving out. What's the court's response to that going to be? You violated the lease first by not maintaining the property. So very rarely do landlords actually go to court over this constructive eviction because they know they usually don't come out well in their case. I mean, it's just not, because most of the time if the tenant is knowledgeable enough to understand what a constructive eviction actually is, they probably have the legal right to it. Because if the landlord is refusing to maintain something about the property, the tenant has that legal right. Yes, ma'am. Does what have to be in writing? No, the idea of constructive eviction, remember, why is the tenant evicting themselves? The property is not safe. right? So you certainly don't, the state would never say to you, oh, but you got to stay there 30 more days while it's not safe. You know, so yes, you have to give it to them in writing, but you don't have to give any sort of notice. You can constructively evict yourself. Now, in writing, absolutely. Now, what the statute actually says is that in order to prove that you are constructively evicting yourself, you also have to show where you've requested the repairs in writing. In other words, you can't just out of the blue, you know, you wake up this morning and my heat doesn't work and I'm just going to grab my mess and move out. You know, that's not the idea of constructive eviction. You have to give the landlord a reasonable opportunity to make repairs to the property. So it's always a good idea when you have a problem in a leased residential property, what's the best way to notify the landlord of that issue? Email. Because there you have a documented, this is the first time I told them about this, so if 2 weeks later it's still not taken care of and you do feel the need to constructively evict yourself, you've documented where you did give the landlord ample opportunity to make that repair.
You mentioned heat. How about AC? Is it required?
It is not required. It's not required. But here's one of the interesting things. And this is a great question because it doesn't apply just to air conditioning. It applies to anything in the property. Heat is required. That's part of a fit and habitable condition. But we go further with residential rentals. Anything that is included in the property has to be maintained by the landlord. So if the property is air conditioned, does the landlord have to maintain the air conditioning? Yes, even if you look in the statute, if you look in the law, it's not going to say anything at all about air conditioning being required. What it says is you have to maintain the property. Well, maintaining the property means maintaining everything that's there. The idea being, would the tenant have paid the same amount of rent for that property if there was no air conditioning? They either wouldn't be living there or they would have paid, it would have marketed for substantially less, right? So therefore, if the air conditioning is not working, the landlord is not living up to their end of the bargain because they're not providing what it is that the tenant bargained for. So that's a long way to say, yes, you could still constructively evict yourself for not fixing something like air conditioning. You could constructively evict yourself for them not fixing a refrigerator. There's no requirement whatsoever for them to provide you a refrigerator. But if you lease a property with a refrigerator in it, guess what? You've got to maintain it. See, when I was a residential property manager, I used to always have written in my lease, this lease includes no appliances. And they'd walk through the house and look and say, oh, I didn't think it included appliances. There's a washer and dryer and refrigerator here. I said, you're exactly right. They are there. And if they work, you are more than welcome to use them all you like. But they are not included in your lease. Because that meant we did not have to do what? To maintain them. Because the truth is, you'd be better off to take them out rather than being on the hook for maintaining. Because if you rent it with them there, you got to maintain them. Does that make sense for everybody? So the tenant can constructively evict themselves basically for any lack of maintenance on the property. It's a pretty broad, and ultimately, you know, the question often comes up, well, you know, how can they do that? Well, that's a question for a court of law. And the only way it's going to get there is if the landlord actually sues them for breaching the lease. And so the landlord would then be in the position of number one, they got to pay a filing fee. They got to go to court. They've got to, you know, and they're going to bring this tenant into court and say, Your Honor, you know what? It was 98 degrees and I didn't fix their air conditioning, but they still owe me rent. How do you think that's going to go? I mean, it's just not going to come out well for them. And so this constructive eviction is a really powerful thing, especially in residential rentals. Everybody got that idea? Okay. Yes.
If the landlord provides you heaters or something in that situation, does that then mean that you can't constructively?
So you mean like temporary space heaters?
Yeah.
I would say temporary space heaters would be fine for a temporary solution. That's not anything resembling a permanent solution, though. And again, it's going to be a very gray area. There's no magic answer here because it's going to be up to whatever judge it gets in front of, if it gets in front of one of them. I mean, most landlord-tenant disputes are just that. They're landlord-tenant disputes, and they never actually make it in front of a judge. I cannot tell you, to flip it from the other perspective, I cannot tell you how many times over the years I've heard tenants come and say, well, they can't keep my security deposit for that. I say, okay, well, what is it? Well, I didn't clean up this. I didn't clean the carpet. They can't keep my security deposit for that, can they? And I say, according to the statute, they can't. Well, they did. Okay. Well, they can't do that. Okay. Well, they did. Okay. You see, we're in a loop right here, right? There's only one place to fix that loop, folks. Where is it? In court. So ultimately, the question for them is, are you willing to go to court over them keeping that fee for cleaning your... Well, I ain't got time for that. Well, then shut up. And I'm not trying to be callous or cold, and I'm not trying to defend a landlord who keeps us... But that's ultimately the only argument that matters, right? Is if you're willing to go to court. Because if you're not, the rest of it's just blustering around and bitching, for lack of a better term. I mean, that's all it is, and it doesn't get you anywhere. Because ultimately, unless you're willing to actually go to small claims court, file that suit, try to recover that money, you're never going to end that argument. And I will tell you that the law very much favors tenants in most of those cases. 9 times out of 10, if money is deducted from a security deposit in this state, it is illegally deducted from the security deposit. And almost never do the tenants actually challenge that in court. They just don't. I don't know why they don't. They just don't. I mean, I remember years ago when I moved to Wake County, I rented an apartment for a year because I didn't know where I wanted to buy a house. I had lived in Orange County for years. I sold my house in Chapel Hill and I moved over here, and I rented an apartment over in Cary near Crossroads Shopping Center. And when I moved out, they had about 3 charges against my security deposit. They sent me the breakdown of what they had done with my security deposit, and they refunded most of it. It was like $150 they had charged against my security deposit for things that were completely not allowed within the law. And so I just wrote them a nice little letter back, and I made a photocopy of the North Carolina Tenant Security Deposit Act. I said, please outline where in the statute it allows you to keep money for this purpose. 3 days later, you know what I got? A check. Because they knew they were wrong when they deducted it in the first place, but they do it anyway because most tenants either don't know any better or don't press the issue. That's as simple as that. When it really comes down to it, tenants either don't know or don't press. Because there are very few things, realistically, that can be deducted from a tenant security deposit. We're going to talk about what those are. Okay? So we talked about this common law of constructive eviction. That is the right of the tenant to cancel for the remainder of the lease and vacate without any penalty. Okay? In that case, if that's the only reason the tenant's vacating the property, then their deposit should be refunded to them, unless there are other reasons. Maybe they also didn't pay rent, or obviously all the same rules are going to apply to the tenant security deposit, no matter what the reason was that they vacated the property. So one thing you need to be aware of for test-taking purposes is this terminology of retaliatory eviction. Basically, tenants can't be evicted because they're paying. That's really what retaliatory eviction refers to. If you've got a tenant who emails you every 3 days because something's broken, you cannot evict them for that reason. They're doing their job. It's your job to maintain the property. I will tell you that one of the biggest frustrations you'll ever have in your career as a real estate broker, you put yourself in that position. You take on managing a residential property that's in terrible shape. Well, guess what? You just inherited that mess. And they have a legal right to email you and call you every single day until you fix all of those problems. So one of the things I always did over the years is when I took on a property management account, we went through the whole house. And I made a list of everything that had to be fixed. And if the landlord wasn't willing to fix it, guess what? I didn't manage the property. Because I knew who was going to be dealing with those midnight phone calls. And it was going to be me. So it's a tough business. There's no question about that. Now, just because the landlord can't evict a tenant for that right doesn't mean the landlord has to keep the tenant around forever. There's never any requirement to renew a lease. So if they just don't like dealing with that tenant, they can certainly choose not to renew their lease. there are some laws now that protect tenants in the event of foreclosure. This was not always the case. When I got into the business, if a bank foreclosed on a property and you were living there as a tenant, you were given 10 days notice to get out of the property. You might have no idea that the property was subject to a foreclosure. You might be paying your rent on time. Can you imagine having paid your rent, being current on your rent, and then getting a notice from the sheriff that you have 10 days to get out? That is exactly how it used to work. Now, however, the bank is required to honor any written leases that are in place. So whenever the bank takes over that property as a foreclosure, they still have to honor those leases. And if they sell the property to somebody else, that person also has to honor those leases. Even if you don't have a written lease, they now have to give you 90 days after the foreclosure action. So much more protection now for the tenants than there used to be. Okay? We mentioned that you cannot use self-help eviction. Self-help eviction will be anything other than the summary ejectment process. So if you want to get, tenants can only leave, the best way to think of it is there's only two legal mechanisms for a tenant to vacate the property: voluntarily or through summary ejectment. Those are the only two ways. They can voluntarily leave or they can go through summary ejectment. Those are the only two ways from the landlord's perspective for the tenant to leave the property. That's it. And obviously, you don't want to go through the summary ejectment process. This is not on the test, but let me just give you a mindset check here. The courts are not where you want to be. That is ugly, expensive, long, just not fun. There are going to be times if you go into residential property management when you sort of have to hold your nose and do things that you think on principle you should never do. But the reality is they make the most sense. I'll give you an example. And trust me, your landlord, your owner that has hired you is going to think you're crazy when you say this. But you have to explain to them why it's not. You got a tenant who hasn't paid their rent. It's the 15th of the month. You have a conversation with the landlord. You say, we need to get rid of Bobby. He's been late 6 months out of the last 7. He's 15 days late now. He's not responding to my emails. He hasn't answered the phone. I put several notes on the door. Haven't heard from him. In my experience, you get that string of things going on. You're not going to hear from them. They're not going to pay. We probably need to get rid of him. Now, 15 days late, can we file for summary ejectment? Yes. Absolutely. And how long is it going to take after we file? 45. Another 45 days. So by the time we actually get this person out of the property, we're going to be 2 months into this thing. Is it likely they're going to pay rent after you file for ejectment against them? No. So now they're going to be at least 2 months late on the rent, correct? And are they going to be in a good mood when they're leaving? So what are they likely to do with your property? Tear it up, right? So these are all the realities of the property manager in that situation. You know what my recommendation to the landlord would be? Let me offer to refund them their security deposit if they'll be out by the end of the week. And cash for keys, that's exactly what it is. And when you say that to the landlord, they're like, are you out of your damn mind? I'm not giving them their security deposit back. They haven't paid me. And they just start barking all this. And I'm like, and so you have to be the one that says to them, well, what would you rather do? Be 2 months out of rent and have them tear your place up? Or get them out by the end of this week? And by the way, I can say to them, I'm not giving you that security deposit back till this place is spotless. I mean, absolutely top to bottom, looks like brand new. You need to paint over those marks on the wall. Can I make all those requirements if I'm going to be refunding them a security deposit that they aren't owed? Yes. Absolutely. And which is likely to be a better outcome for my landlord? You see what I mean? Avoid court like the plague. Only go if you absolutely have to. And the shocking thing is, that person who won't answer your phone calls or emails, you put a note on the door that says, hey, Bobby, I'd like to talk to you about refunding your security deposit. 3 minutes later. I mean, you know, the one that pretended they weren't home before you could get to the end of the street. Hey, I found this note. Oh, I didn't think you were home. Yeah, I was in the bathroom. Yeah, okay, sure. But they will work. So you got to think creatively when it comes to stuff like this, because just because summary ejectment is the legal process does not mean it's the most efficient one, okay? That's all I'm getting at here. There's always another way. If they will voluntarily exit the property, then by all means give them that security deposit back, because it'll be a better outcome. Especially if you say, I'll give you your security deposit back, and when somebody calls me asking about where you're going to rent the next time, I'll tell them you were a wonderful tenant. They will leave. It works. Okay. So let's talk about that. Excuse me, that security deposit and what the North Carolina Tenant Security Deposit Act says. First of all, I'm going to skip to the next slide and I'll come back to this one. The first thing you need to know about the Tenant Security Deposit Act is right here on the bottom of this slide. A tenant security deposit in North Carolina must be held in a trust account. I don't care who's holding it. I don't care if a real estate broker is involved, if the real estate broker is not involved. If there is a tenant security deposit, it must be held in a trust account. So that means if your cousin is renting out his house that he owns and he holds a tenant security deposit, what does your cousin have to do? Open a trust account and know all the rules of a trust account and follow those. How often do you think this law is violated?
All the time.
All the time. Here's the danger of violating this law, the penalty. You have no legal entitlement. All these things that we're talking about that you can deduct from a security deposit, that all flies out the window if you don't hold it in the right place. Because if that tenant challenges you in court, if they take you to court and say, no, you owe me my security deposit back, and the landlord says, I don't owe them back. They didn't pay me rent. They owe me this. They owe me that. And the judge looks at the tenant and says, well, what's your response to that? The tenant can literally say this, Your Honor, I haven't paid them rent for the last 6 months. But they did not hold that tenant security deposit in a trust account. They put it in their bank account. And you know what that judgment's going to be? Tenant gets it back. Because the first rule of a tenant security deposit is it must be held in a trust account, no matter who's holding it. Okay? So what are the things that the tenant security deposit does? It limits the amount of a security deposit. Yes, Gray?
How would the tenant know where the money was?
Well, it's a good question. How would the tenant know where the money is being held? That's one of the things you have to disclose to the tenant. The Act says you have to tell the tenant where the security deposit is being held, what bank, what address, and what account number that it's being held in. That is, it's on. If you use a standard lease, it's already printed on there, but the tenant is entitled to that information. They can make a demand at any time to say, where's my security deposit being held? And while you can't, as a layperson, walk into that bank and say, show me my security deposit in this account, what you can walk into that bank and say, what is the name on this account? And if that name doesn't say trust account, they know. They know. So they'd have to be very knowledgeable, but it's up to the landlord to prove it is indeed in a trust account. Okay? So what does the Tenant Security Deposit Act do? First of all, it limits how much of a security deposit we can charge. We can't just charge whatever we would like. And you need to know these time periods here. So these are maximum tenant security deposits. Do we have to charge the max? No, we can always charge less if we'd like to. We don't have to charge the maximum amount. So if it's a week-to-week tenancy, the most we can hold is 2 weeks. If it's month-to-month, we can hold 1.5 months. And if it's anything longer than month-to-month, we can hold up to 2 months worth of a security deposit. That's the max. So never more than a 2-month security deposit. And also one of my favorite things is when people refer to a security deposit as something other than a security deposit. Oh, we don't hold security deposits. We do first and last month's rent. That's a security deposit. Okay? Anything other than this month's rent is a security deposit. You can call it whatever you'd like, but the state of North Carolina will consider it a security deposit. Okay? So, what does it allow us to do with that security deposit? These are the things that the landlord can be reimbursed for from a security deposit, but not until the tenant has left the property. Never while the tenant is still occupying the property. Non-payment of rent. Damage to the premises. Now, damage is not ordinary wear and tear. That's in red down here on this slide because that's going to be on the test, I guarantee you. Some reference to ordinary wear and tear. Ordinary wear and tear may never be deducted from a security deposit in this state. And you know what the first example of ordinary wear and tear is in the law? Cleaning expenses. You cannot deduct cleaning expenses from a security deposit in this state. They do have an exception there that says the one exception is in the case of exceptional filth. Now, people may define exceptional filth differently, but what I'm saying to you is if you're going to deduct money for cleaning from a security deposit, you better have some pretty detailed pictures and it better be pretty gnarly, whatever you're charging for. Yes?
What if the lease says that upon move out you have to get your carpets professionally cleaned?
Wonderful question. Sarah's question is, what if my lease says upon move out I have to get my carpets professionally cleaned? The lease can indeed say that. And they can indeed charge you for it, but they cannot deduct it from the security deposit. So they could send you a separate bill, so they'd have to refund your security deposit and say, oh, by the way, you owe us $200 because you didn't clean the carpets, and your lease says you would. But they cannot deduct that $200 from the security deposit. Does that help? You see? So they can certainly bill you for cleaning, because they can put in your lease that you've got to do this, you've got to have the carpets cleaned, but they can't deduct it from the security deposit, because the Tenant Security Deposit Act explicitly says no, can't do that. Basically, things that are broken. When we start talking about property condition, the only things that you can deduct from a security deposit are things that the tenant has broken. And carpet gets into a very gray area even if the tenant tore it up. Because we actually have guidelines in North Carolina, for example, you don't need to know this for a test, but just to give you an example, that say carpet has a lifespan of 7 years. So, you know, if you go as a landlord and try to deduct, let's say they have an animal that claws at the carpet. Y'all have cats, right? You know this little number that cats do. Making biscuits, is that what people call it, or whatever? You know, and you come in there and look, and it's Berber carpet, and there's a run that goes all the way from one side of the room to the other. Even that is not going to be considered damage if the carpet's more than 7 years old. Because what a magistrate in North Carolina would say is, well, you were planning to replace that carpet anyway, right? Because it's more than 7 years old. So you can't charge a tenant for it. So it gets very dicey about what you can deduct from a security deposit. Yes, Gray?
I'm sorry, I don't mean to ask any questions.
No, you're fine.
Where can you go to get the list?
You can actually pull up the Tenant Security Deposit Act. So you could just Google North Carolina Tenant Security Deposit Act.
And would the carpet be on the Tenant Security Deposit Act? The lifespan of the
Yes, it's all mentioned. There's a lot. All the guidelines are in there specifically about what you can and cannot charge for. And it'll even get down to like holes in the walls. It'll say you cannot charge for small holes for pictures, for example, but you can charge for large holes. So like somebody mounts a TV on the wall and puts the bolts into the wall. You could charge for those holes, but if they're just hanging pictures, you can't charge for that. It says you can charge for marks, drawings on the wall, but you can't charge for dirty walls. So somebody's got kids, and you ever seen a house that has kids that go up the stairs and the wall, you can see the line of how tall they are, right? There's hands just on everything. You can't charge for that. Not against the security deposit. If you have a lease that you could have a lease that says you have to have the house professionally repainted when you move out. That's fine, but you can't deduct from the security deposit for it. Does that make sense for everybody? Very limited about what, these are the things you can deduct. Non-payment of rent, damage to the premises, non-fulfillment of the rental period, but there's a big catch there. Technically speaking, in North Carolina, you should not have leases that have a specific amount we charge when somebody violates the lease. And I know everybody does it in the resident. How many of you have seen a lease that says if you break your lease, you owe us too much rent? You're not supposed to do that in North Carolina. And the reason is the tenant actually owes for all of the rent if they break the lease early. But here's the big catch to that. The landlord is legally required to try to re-rent the property as quickly as possible. And they have to stop charging the old tenant as soon as they get a new tenant. That's why the state doesn't want you to put this, you owe us too much rent, because that presumes it's going to take 2 months to re-rent the property. Does that make sense? Okay. Cost of removing their junk or court costs. All of those can be charged against a tenant security deposit, but never ordinary wear and tear, and never things that the landlord's supposed to be responsible for maintaining anyway. I mean, I had somebody one time that tried to deduct, a student brought to class, she brought me where she had moved out, and they deducted the cost of replacing the fill valves in the toilets because the toilets were leaking. And I said, that's the damn landlord's responsibility anyway. I said, you should be deducting, you should be suing them money for rent that you paid in water that got wasted while the toilets were leaking, not the other way around. So it's amazing what some people will deduct from a security deposit. And again, it can't be deducted until the tenant actually vacates the property. And then you need to know this 30-day period. After the tenant vacates the property, the landlord has 30 days to notify the tenant in writing of what they did with their security deposit. So either to refund it in full, refund a portion with some explanation of what they deducted, or just send them an explanation of we kept your security deposit because of. And you have to give an itemized list. If you don't do this reconciliation within 30 days, you're also not legally entitled to the security deposit. The most common question here is, well, where do I send it? You send it to their last known address, which often is where? Your property, right? But, it's up to them to have forwarded their mail or done whatever. You just need to send the reconciliation. Don't just assume, well, I don't know where they went, so I can't send it to them. Send it to their last known address. And that way you have proof that you've done what you were supposed to do.
It can't be emailed?
It can be emailed because it says in writing. I think you're always better to send something like this certified mail, just because you have much more of a verification that you've done it. But email would conceivably work. I would say, best practices would be certified mail for something like this.
So say it had been like 35 days and you hadn't mailed it out yet and you were deducting $200 from their security deposit. Because it's been 35 days, you have to now give them back their full security deposit.
Correct. But again, the only way that's going to get challenged is if they know the law and take you to court over that $200. So it definitely is. What can happen and what does happen are often two different things when it comes to tenant security deposits. Okay, and we talked about damages. You cannot charge for ordinary wear and tear, but you can charge for damages above ordinary wear and tear. All right. Just a quick note here on public housing or subsidized housing, also known as Section 8 housing. With Section 8 housing, for those of you who are not familiar with the process, the tenant has a voucher from the government to cover a portion of their rent. And that portion could be 100% of the rent, it could be 50% of the rent, it could be, it's a stated dollar amount. You don't have to, in North Carolina, accept public housing tenants. You can have a policy where you don't accept public housing tenants or where you do accept. The obvious benefit of accepting public housing tenants is the voucher portion of the rent is pretty much guaranteed. Those checks come every month without fail, on time. Now, the downside to accepting Section 8 tenants. Non-payment of rent is not a valid reason for eviction. We'll say that again. Non-payment of rent is not a valid reason for eviction. So what that means is that whatever is left after the voucher that you expect the tenant to pay, if they don't pay, that's not a reason that you can evict them for it. So if you're going to accept Section 8 tenants, I would suggest you weigh that reality, and so I would probably not, advise accepting Section 8 tenants where the difference between the voucher and the actual rent was a very large one, because you're not going to have any recourse if they don't pay that amount. Do they typically know that? I have never honestly managed a property where we accepted Section 8 vouchers, because all my property management experience has been here in the Triangle, and we just didn't have to. It was always competitive enough that we could, rent the property without going through that process. And so, generally speaking, it's one of those things where you don't accept them unless you have to. And the reason is, it's not just this fact that you can't evict them for non-payment. Also, damage to the property, the landlord's responsible for it, not the tenant, which is very different than the normal landlord-tenant scenario. And so where these are common are in areas where you just can't rent the property without accepting them, where the vast majority of potential tenants would be in a subsidized housing program. So more rural parts of the state. What I hear from people who manage in those areas is that, it's just a reality that they have to deal with it. And that, to answer your question, a lot of them do know that. Based on what I hear from people who manage property in more rural parts of the state, is that the tenants are aware that, they can't be evicted for not paying that difference. And so what they generally do as property managers there is, if somebody has a voucher for $700, they might be willing to rent them a property that rents for $750, because they think, well, if I don't get the $50, that's not the end of the world. But they would not be willing to rent them a property that rents for $1,000, because they know that, there's a good chance they're not going to pay that gap. Yes, ma'am.
And you say you can refuse those tenants, that's not any,
So Mahogany's question is, can I refuse to accept Section 8 tenants? Yes, absolutely. You're not required to accept Section 8 tenants. But where you would get into trouble is not being consistent with that. Saying, well, maybe, we'll evaluate it at that point. No. You either do take them or you don't. And once you've gone down the road of saying you do accept Section 8 tenants, then you better accept all of them equally. But in North Carolina, you can choose not. That's not a protected class of individuals. You can choose not, because it's based on how they pay. You can choose not to accept the vouchers. There are some states where you're not allowed to do that. For example, California, you have to accept all tenants regardless of source of income as a protected class. So you can't refuse them. But in North Carolina, that's not the case. Okay? The Vacation Rental Act. So basically, the Vacation Rental Act is there to get rid of all those regulations we just talked about. Think about a vacation property. Think about the two ways that I said you could get rid of a residential tenant. They can either leave on their own, or you can do what? File for summary ejectment, which takes how long? 45 days. That's kind of a long time period to get somebody out of a beach house, right? So the Vacation Rental Act exists specifically to exempt those properties from the Residential Rental Act. Basically to say, if this is a vacation type rental, we don't have to follow all those rules that are there for residential properties. Does that make sense for everybody? It's just it's basically an exemption. It's like a way of saying, because this is a vacation rental, we don't have to give all of these rights to a tenant necessarily. The biggest one being quick eviction. Remember how I said, you can't do self-help eviction, like show up on somebody's doorstep with a shotgun, according to the Residential Rental Agreements Act? Guess what you can do if it's a vacation property? Show up with a shotgun. because it's exempt from all those protections of the Residential Rental Agreements Act if it's a vacation property. So in order for it to qualify as a vacation property, the rental always has to be less than 90 days. That's the big rule. And the tenant has to have a home somewhere else. So basically you have to verify that they do have another home to go to somewhere else. So when you rent a vacation property, they're going to first ask you for your home address. That's proof that they have a home somewhere else. And it would always be for less than 90 days. And that's all you need to know about it, really, realistically. The book gives you a lot more details about that. You know, like for example, it says if you buy a vacation property, you don't have to honor all of the leases. You only have to honor them for the next 6 months. You know, if you, for example, if you buy a beach house down at Atlantic Beach and you want to use it for your own, and it's got reservations for the next 10 years, because that's possible with a vacation rental property, you don't have to honor all those reservations. You only have to honor them for the next 6 months. And then you could cancel everything past that point. Okay? Everybody good on that? All right. Now, I want to talk about, so that now we've gotten all the residential rules out of the way, turn back to page 325. And we want to talk about the different types of leases, because all those rules went along with residential leases. But leases come in different varieties. We need to talk about the difference between an estate for years and a periodic tenancy. We're going to also talk about estates at will and estates at sufferance, but really, I want to focus first and foremost on the difference between these two, because this is going to show up on a test somewhere, and you're going to get it wrong, because you're hard-headed. The leases you are accustomed to dealing with are not for definite periods of time. How many of you have ever leased an apartment, a house, somewhere to live? You've ever leased one in North Carolina? That lease was not for a definite period of time. It wasn't. You didn't have a 1-year lease. You might have had a lease that was initially for a year, but you had a lease for an indefinite period of time. You essentially had a lease forever, because the lease you had automatically renewed itself, because it was a periodic tenancy. And here's how I know it was a periodic tenancy. When you had that lease in writing, it said if you wanted it to end, you had to do what? Give notice. And if you didn't give notice, or if the landlord didn't give you notice, it would automatically do what? Renew itself to month, is usually what they say, don't they? But they automatically renew. That is a periodic tenancy. Periodic tenancies automatically renew themselves. In other words, I give notice to terminate them. If the landlord doesn't give the tenant notice, or the tenant doesn't give the landlord notice, what's that lease going to do? Keep right on rolling. Renew. As long as the tenant keeps paying rent, as long as the landlord accepts it, guess what the lease does? Keeps rolling. That's a periodic tenancy. And I know that's what you had, because in North Carolina, all residential leases are periodic tenancies. Every single one of them. So let's talk about the other one. The estate for years. Here's the first thing you got to get out of your head, that last word. Years. It doesn't mean anything. Because an estate for years is a lease for any fixed amount of time. Any definite amount of time on a lease is an estate for years. Travis leases a vacation home for 2 weeks. This is an example of, what is it? That's an estate for years. Any definite period of time. So, If I give notice in a periodic tenancy because I want the lease to terminate, why would I give notice in an estate for years if I wanted the lease to do what? To renew. The key here is what it does automatically. An estate for years automatically terminates. Nobody has to give you notice. Nobody has to say, hey, Gray, your lease is up in a month. What do you want to do? You're expected to know. And if Gray intends to move out, he doesn't need to give the landlord notice that he intends to move out because it's expected the landlord understands he's going to do what? Move out. An estate for years just ends. Period. End of story. Nobody has to tell anybody about it. Nobody needs to warn anybody. Whereas a periodic tenancy, you have to give what? Notice. It's so nice. That's why it's residential. Because residential is nice. Guess what most commercial leases are? Estates for years. You get out. Nobody has to remind you to get out. It's expected that you understand that. If your lease expires on December 31st, your butt better be out of there on December 31st. Not all commercial, but the vast majority. I said all residential are what? Periodic. The vast majority of, because if you're the landlord, which one of these do you prefer? One that's going to automatically renew or one that's going to be very clear and end on a certain date? Which one is better from a landlord perspective? Hey, automatic renewal, really? You think so?
Oh, because you can't jack up the...
Exactly. I want one that just ends if I'm the landlord. Because I want the tenant to have to come to me for renewal. I don't want them to have guaranteed renewal. Because not only are they roped in, I'm roped in. That's the problem with a periodic tenancy from the landlord's perspective. I'm just as bound as they are.
So when you get like a notice and you have, like, say I rented an apartment for 12 months, and I get a notice 60 days before my lease ends, and it says your rent will go up by $50, and I don't let them know that I'm staying. It auto renews and my rent goes up.
That's right. That's exactly right. Because they've told you what's going to happen.
So they've notified me. So it can't go, the rent can go up. But
Yep, but they would have to notify you to do it.
Right. But unless I tell them I'm moving out, it auto renews.
That's exactly right. That's exactly right. And it could auto renew year to year, week to week, month to month, whatever the lease. Most common it says month to month that it's going to auto renew. The key here is it's not for a definite period of time because of the auto renewal. Whereas the estate for years, cut and dry.
I'm stuck on the commercial, like wrapping my head around a commercial landlord. Why would they want an automatic cutoff?
Why do they? Because it's clean. Because it's clean. There's no question about it.
They could get somebody else in, or
Absolutely. They can go shop around for somebody else the day after. Right? And they don't have to worry about remembering, oh, Tina's lease expires next month. I got to send her a written notice. See, they don't want to do all that running around chasing their tail.
But is it expensive for the commercial leases? A lot of times aren't the tenants asking for some modifications?
A lot of times they are, right. So it's not that they don't want to renew them. It's that they don't want to have to pay attention. They want the tenant to have to come to them.
Don't some of the commercial leases have it, like an escalation clause?
A lot of them have escalation clauses. They do. Not the same thing. No. This just deals with the basic structure of the lease. Does it automatically renew? Does it automatically end? And on a test, they're going to want you to recognize the difference. Any definite time period is what? Estate for years. That's exactly right.
Is there a cap to the length?
No.
That could be, so you could
No
say
cap to the length at all.
20 years or whatever.
Could be. In fact, we talk about ground leases later on. The most common term for a ground lease is 99 years. So they can be for a very long time. But any definite time period is an estate for years. Now, estates at will and estates at sufferance, I don't want to spend much time on. Basically, these are ones where most likely no rent is being paid. Okay? If, for example, an estate for will is just permission to be there. You can stay there if you want to. Who's bound by that? The tenant or the landlord? Or neither? Neither. You can stay there if you want to. Because if I give permission, I can do what anytime? Take it away. Is the tenant required to stay there? The tenant owe me anything? No. It's just permission. The estate at sufferance is not permission. It's you're there without permission. You were supposed to leave, but you didn't. A lot of times we call that a holdover tenant. They're supposed to have vacated, but they have not. Here's why I say no rent's being paid. You take this holdover tenant, this tenant at sufferance, the one who was supposed to be out on the 1st, but they ain't. And you go knock on the door and you say, you were supposed to be out of here. Oh, I know. Here's a couple $100 to cover these 2 weeks. I'll be out on Friday. Guess what you just created? Nope. A periodic tenancy, which automatically does what? Renews. And guess what the new rental amount is? Whatever they just paid you. You just renegotiated your lease. You just created a month-to-month periodic tenancy for whatever amount they just paid you. Because acceptance of rent in North Carolina is proof that you agree to be bound by a periodic tenancy. You don't accept partial rent payments. Ever. Under any circumstance. Yes, ma'am.
I'm trying to get this down. So, a periodic tenancy is anytime they say, okay, you got this lease for a year, but you have to give X amount of notice before you move out.
That's a periodic tenancy. That's it.
Periodic.
Yep.
But then if you got one that says your lease is till December 2018.
That's it. No more.
That's where
That's an estate for years.
Unless you come to us and renew.
That's right. You can always come back, but there's no guarantee that they have to renew. There's no guarantee that conversation has to take place. Literally, no more conversation has to take place with an estate for years. The problem with a periodic tenancy is there has to be further conversation. Because if you say my lease ends on December 31st and you just move out on December 31st, guess what? You violated your lease. Because it said you had to give what? Notice. You have to give notice. That's a periodic tenancy. Anytime it calls for notice, that's periodic.
If you have a holdover, do you still have to go through the court to do a proper eviction? So you still can't self-evict.
Correct.
You can't change the locks or anything.
Nope.
Like that.
That's exactly right. That's an estate at sufferance. And you have to still go through the summary ejectment procedure to get rid of them.
Repeat what you said before. You said an acceptance of rent means.
Means you have agreed to a new periodic tenancy. Because here's one of the problems. It sounds wonderful. We say, oh, leases are great because they don't have to be in writing. Leases are not covered by the statute of frauds in North Carolina. So they don't have to be what? In writing. The problem with not having one in writing is the court doesn't know what you meant. So what it assumes you meant is month to month, periodic. That's like the basic one, right? And so if you have a verbal lease and somebody pays you rent, the court says that's month to month, periodic. Well, if somebody pays you rent and you accept it, guess what? The court says that's a verbal lease. And so therefore it's month to month, periodic. So that holdover tenant, you just lease them the property for a whole other month for whatever they just paid you. So the best thing to do when they offer you that $200 is say, no. You keep your $200. Get out. I want you out. Now, somebody said, well, is there any way I can take the money? There is. You could go to an attorney and have them draft an agreement that says, I'm accepting your $200, but this does not constitute, but that's a whole lot to go through just to accept $200 from somebody. What I'm saying you should not do is just accept the $200 without some other written agreement, because then you've created a new lease.
Is the term holdover tenant referring to the tenant that's still in the property while you're going through that 45-day process?
No,
Okay.
that's somebody whose lease has expired and they're still there.
Okay.
So in the case of a periodic tenancy, their lease expired on September 30th. You gave them proper notice. You said, you're supposed to be out. I'm not renewing your lease. And they still didn't leave. That would be in the case of a periodic tenancy. If it was an estate for years, they had one that ended September 30th and they didn't get out because there's no notice necessary in an estate for years.
And that would be the same thing as if I leased somewhere. I said, I'm going to be out in 60 days. I'm not renewing my lease, and then I'm still there. Would that still be a lease holdover?
Yes, absolutely. Absolutely. Okay? So, let's talk about payment of the rent. And by the way, if you look at the periodic tenancies in your book on page 326, they do give you the minimum notice requirements there. I would take a look at those if I were you. The minimum. Now, could a lease specify more notice than this? Yeah, you can always go more. You can't go less. So minimum notice for a week-to-week tenancy, for example, is 2 days in North Carolina. And that's either from the landlord's perspective or the tenant's perspective. For month-to-month, it's 7 days. And anything longer than month-to-month, it's 30 days, or 1 month. You have to give a month's notice. Minimum. Okay? Those are periodic tenancies. So let's talk about how we pay the rent. Those are the legal structures of the lease. Now let's talk about how the rent's paid, because that's a separate deal. You could have, for example, any of these could be either periodic or estates for years. Gross payments, gross lease or fixed lease payments. These are the ones you're most familiar with in residential leases. Residential leases are always going to be a gross lease payment. Commercial could be either gross or what we're going to talk about next, which is net. The opposite of gross is always net. A gross lease payment means the tenant pays one amount and that's all they're ever responsible for. If there are additional expenses like taxes and insurance and maintenance, who's going to pay for all that? The landlord. Tenant pays one amount, landlord's responsible for all the expenses. That's a gross lease. All residentials are always going to be a gross lease because who's responsible for maintenance and all those things on a residential? The landlord is. Most commercial leases, I'm going to skip ahead actually to this one, are the net lease. In a net lease, the tenant not only pays rent, but they also pay the other expenses relating to the property. The most common example of these is actually called a triple net lease because the tenant pays the taxes, the insurance, and the maintenance. Those are the three. That's why it's called triple net. The tenant, in addition to their rent, pays for maintenance on the property, taxes, and insurance. What's the benefit to that of the landlord?
You don't have to worry about things they need to fix.
They don't have to worry about things they need to fix. Well, I don't have to worry about not only that, but taxes or insurance. So what's the benefit to the landlord long term? They know what's never going to change. The amount of money that ends up where? In their pocket. Taxes go up, do I care? No, because who's paying them? The tenant. Air conditioning blows up, do I care? No, matter of fact, I probably like it because they have to do what? Buy a new one for my building. Commercial landlords love a net lease because it helps them regulate their cash flow. Other lease payment you need to be aware of, the percentage lease. A percentage lease is a retail lease. This is used in a retail setting because the rent is based on a percentage of sales. Shopping malls almost all universally rent space in this manner. If you go rent a store in Crabtree Valley, you would have a percentage lease. You would have some base rent, which would be very low. You'd be like, oh, that's all I have to pay to be here? Oh, and plus 20% of your sales. Why would a shopping mall do it this way? Take advantage of the busy season. Why would a retail tenant want it to be this way? Look at it from the other perspective. In January, they're not paying much rent, right? They pay a very minimal amount because their sales are terrible. And the other reason you'd want to do this from the tenant's perspective is you want the landlord to have buy-in. You want the landlord, because think about all the things that the mall does, for example, to drive traffic during that holiday season. All the decorations, all the programs they have going on. Well, the mall's paying for all that. The reason the mall's willing to pay for it is because they drive more traffic into those stores. That drives more sales. That drives more rent. Does that make sense? That's why we call these retail leases. All right? You don't need to know about graduated leases, index leases, ground leases. A ground lease, which is on page 329, this is when we lease the land to build something. We're going to build a building. We're going to construct something, but we're not going to do it on land we own. We're going to lease the land. One of the most common, or two things I can think of right now in North Carolina that you would see this used for, cell phone towers and solar farms. Almost always in cell phone towers and solar farms, that is leased land that we're building these structures on. So if you think about it, if you're building something, you probably want a pretty long-term lease, don't you? I mean, if I'm going to build a solar farm, I don't want a 2-year lease. I'd want a 99-year lease. Very long. Long-term. Those would be the only ones I would think you would see on a test. As far as this essential provisions of a lease, I'm not going to spend a lot of time here because we just talked about the essential provisions of a contract. And guess what? It's the same thing. Leases are contracts. We need competent parties, right? We need a capacity to contract. That's competent parties. So they can't be, what? Minors. They can't be drunk, right? Under duress, under undue influence. They got to have none of those things. We got to have considerations. There has to be money, something of value exchanged. Got to be a mutual agreement, and it's got to be for a legal objective. All the same rules apply for leases as any other contracts. As far as common things that are there on leases, what can the tenant do with the property? What can they not do with the property? Can they install fixtures? Who's responsible for repairs? All of those things would normally be addressed in leases. Now, turn in your book. I want to point out something to you. Page 331. In the middle of page 331, there's a word there that people are not familiar with that I'd like for you to put in your notes. Upfit. Where it says upfitting improvements, and it's got commercial leases in parentheses there. Does everybody see where I am? Here's what an upfit is. An upfit is a customization. It's a customization. Here's what it's not. It's not updating. It's not fixing up. They'll use those words because it sounds right. That's not what it is. An upfit is a customization. So if I have a commercial tenant coming in and they are going to do a nail salon, what are some customizations to the space they might need? Plumbing, electrical outlets, all the plumbing fixtures for the foot baths and all that sort of thing. So they don't want to pay for that. The tenant doesn't want to pay for that. Could I, as a landlord, negotiate paying for that for them? Could I? That's an upfit. Why would I pay for it for them if I'm the landlord? To get the tenant. To get the tenant. It's what I do. I dangle it in front of them as an incentive for them to lease. And does it have to stop at plumbing? Could I outfit the whole place for them? Sure I could. If I wanted to get tenant. And I'm pretty willing to do that. If they're willing to do what? Pay for it in rent. So pay more rent and for a longer period of time. Pretty much everything's on the table when you're a commercial tenant. You can walk up to a landlord and you can spend $0 on your space. Heck, I did it in this space. I didn't pay for this room used to be 6 offices. I didn't pay for taking that out. Well, at least up front I didn't. I'm paying for it every month. And I traded off. I could have taken this space as is and paid for all my upfit. Rent would have been cheaper and I could have leased it for 3 years. You know what I agreed to? Higher rent for 7 years because they paid for it all. That's an upfit. When they customize the space to the way I needed it, that's an upfit.
No, sometimes vacant too on like in the next 7 years, if you renew again and need other things done.
Mm-hmm.
you negotiate.
Absolutely. So negotiated upfits at renewal. Yeah, absolutely.
So on the slide, that
It says upfit, not uplift. Yeah. You feel uplifted when you get an upfit. Okay. Assignments and subleases, which are also on page 331. Assignments and subleases. So an assignment, just like any other contract assignment, when we do an assignment, what are we changing? The parties. So an assignment would be where one tenant, for example, comes off of a lease and a new tenant goes on to the lease.
Would the original tenant still be responsible if the sub?
Well, it really depends on the situation and how it is done. Most of the time, they still retain some responsibility. They don't, because the landlord's never going to release them completely from being responsible, but it would be like secondarily liable. Whereas with a sublease, that original tenant doesn't even come off the lease. With a sublease, they stay on there, so they are primarily liable for the payment of the rent. They both function the same way ultimately, but the difference is just to do with liability. But from your perspective, assignments and subleases are just a way to change the parties on the contract. Okay? And usually they have to be allowed by the landlord. Much more common in commercial settings, obviously, than residential. You'd almost never see an assignment or a sublease in a residential setting. But in commercial, you see them a lot because businesses go out of business quite often and have long-term leases. Okay? We're not talk about all that. As far as landlord's right to enter, they don't have one. That's what a lease is. You sold that away. If you're going to maintain some right to enter the property, it better be in writing in the lease. There's a specific legal term for taking the keys out of your pocket and opening up that house that you have rented out. Does anybody know the legal terminology for that? It's called breaking and entering. And yes, that's exactly what you would be charged with.
So when they ask like to do an inspection, when you rent an apartment and
Mm-hmm.
say, oh, we want to come in at this time and do this, or we want to come in and change the filter or whatever, they can do that because they're giving you notice and they're asking permission,
They can do that. Why?
because they actually change stuff.
Well, they do have an obligation to maintain, but yet still wouldn't get me to the why they have the right to enter. They have the right to enter, and they would only have the right to enter if they had done what initially? Where does it have to be? In the lease itself. If they don't have it in the lease itself that they have the right to enter for that purpose, do they have the right to enter? No. If the lease doesn't especially say they have the right to enter, then they don't at all for any reason. So if they're going to exercise that right, they better make sure that lease has it in there. Because if the lease has it in there and the tenant signed the lease, the tenant has given them that right to enter the property.
Are you saying that commercial leases, they don't usually give them that right to come on the property? Or?
I'm saying that in any lease, if the landlord intends to enter the property, they better have it in writing. So even in a residential setting, the lease better say they have a right to enter the property or they don't have the right to enter it. At all, for any reason. Care what the excuse is. Unless there's some danger to the property or something. Now, it'd be different if there was water flooding out the doors or something like that, then obviously you have an emergency right to enter to figure that out. As far as this slide about terminating leases, you terminate leases just like you terminate any other contract. They are contracts. Okay? They are contracts. You terminate them the same way. The best way to terminate any contract is with what we call full performance of the lease. That means we've done everything we promised to do. By far the best way. Of course, we could terminate with mutual agreement. The two parties agree or the lease expires, that sort of thing. turn to page 333. I want to talk to you about this slide. And I want you to add something here on third parties. It had this on here and somehow got deleted from the slide. On third parties in that second bullet point. Must be recorded to be enforceable on third parties. It's not another bullet point. It's just it should be right here. Must be recorded to be enforceable on third parties. So let's talk about this rule here. First of all, there is no rule that says leases have to be recorded. Contract or no contract, leases don't have to be recorded. And leases never have to be recorded to be enforceable between the parties that sign the lease. So if Emily leases me a commercial property for 10 years, she does not need to record that lease. I don't need to record that lease. That lease does not have to be recorded. That lease is fully enforceable as long as it's in writing. So how long does she have to lease the property to me? 10 years. How long do I have to pay her? 10 years. Fully enforceable. Doesn't need to be recorded. However, we run into a wrinkle if Emily decides to sell the property. Normally, if Emily decides to sell the property, what happens with the leases? It transfers to the new owner. The new owner has that. So she's selling the property to Chris. If that lease is not recorded, Chris does not have to honor it when she buys that property because it was for longer than 3 years. As a protection to her, Chris, the buyer, she only has to honor leases that are either less than 3 years or ones that are more than 3 years and have been what? Recorded. The idea being that when she's buying the property, she's going to do a title search. And anything that's recorded is going to come up in that title search. So she would be well aware of this long-term lease because she had done a title search on the property. Does that make sense for everybody? So now let me flip that question around. In whose best interest is it to record this lease? The tenant's best interest. It's in my best interest to record that lease because I want to make sure that if Emily sells the property, the new landlord has to do what? Honor that lease.
So,
Go ahead, Gray.
would the new buyer, if they wanted to continue to lease it, would the person who is leasing it be bound to the original agreement?
That's a great question. Gray's question is the tenant bound? So in our case, Emily sells the property to Chris. Is the tenant still bound by the lease? What do you think the answer to that is? Yes, absolutely. Because the tenant signed the lease. The tenant signed it. They're bound. Whether it's recorded or not, the tenant's bound. It would only be the new owner who would be released from that responsibility. So if you think about it that way, that's best case scenario for the new owner, right? And therefore, best case scenario for Emily who's selling the property. If I don't have that lease recorded, here's what Emily's going to say to Chris. Hey, this dumbass over here, he didn't record his lease. So he thinks he's got 7 years left on that lease. When you buy this building, you can double his rent on day one or tell him to get out because you don't have to honor it. It becomes a unilateral contract. That's wonderful right there, right? So in whose best interest would it be to record that long-term lease? The tenant, so that I make sure that new owner has to honor it. Okay? Leases don't have to be recorded, but it's in the tenant's best interest to do it if they are longer than 3 years. And that's it for Chapter 11. Good? Okay? I think we should probably take lunch at some point today. What do y'all think about that? See you at 2:15.